Hey everyone, and welcome back. So, in today's explainer, we're unpacking something pretty massive: the incredibly fascinating and, frankly, super complex mechanisms that govern state power. We're going to be talking about the shadows of power, accountability, proxy wars, and civil rights. My absolute goal today is to kind of demystify these giant concepts for you so we can really grasp how authority actually operates and how sometimes it manages to avoid the very laws that were literally written to keep it in check.
Right off the bat, I want you to ask yourself a question. Who actually polices the police? And how do governments avoid accountability? It's a huge question, right? I want you to picture state authority as this massive iceberg. What the law simply states in black and white, that's just the tip of the iceberg visible above the water. The hidden reality beneath the surface is this vast, complicated ecosystem of secret operations, incredibly specific legal interpretations, and these high-level shields that protect the people in charge.
All right, let's get into Section 1, the illusion of accountability. So let's kick things off with a piece of domestic law. We're talking about 18 U.S.C. Section 242. You'll often hear this referred to as the color of law statute. Now, this isn't some new rule. It was originally enacted right after the Civil War back in 1866, and its entire purpose was to keep law enforcement and public officials in check. Basically, it makes it a federal crime for anybody who is acting under the authority of the law to willfully deprive someone of their constitutional rights.
And what's actually really interesting here is just how wide a net this statute casts. It protects every single person on U.S. soil, period, regardless of their legal status. There's actually federal case law that backs this up brilliantly, specifically a Ninth Circuit case involving Border Patrol called United States v. Autherson. In that particular case, federal agents were prosecuted for assaulting detainees, and the court flat out ruled that these constitutional protections, they apply to everyone, even undocumented individuals.
But here comes the catch, and it is a staggering statistic. 98.7%. According to a track report that analyzed early 2004 data, almost 99% of color of law referrals to the Justice Department resulted in absolutely no charges. Out of 230 matters that were disposed of in the first quarter of that year, 227 were just flat out declined. No way around it. That is a massive drop-off.
So why is that happening? Well, a deeper dive into why those cases were dropped reveals a pretty stark reality. 69% of them were declined for a lack of evidence or criminal intent. Because here's the thing, the statute requires prosecutors to prove specific intent. They have to prove a willful deprivation of rights. And that incredibly high evidentiary burden, it essentially creates an illusion of accountability. We've got the law on the books, sure, but practically speaking, almost no one is actually prosecuted under it.
Moving on to Section 2, shielding the architects.
Now let's look at how this plays out at the very top. The 2014 Harvard Law Shadow Report to the United Nations is a really important document here. It impartially details the persistent, ongoing calls by civil society organizations to actually prosecute top U.S. officials. What for? For authorizing the CIA's post-9/11 detention and interrogation program. And the sheer scale of this program was frankly staggering. It utilized techniques like waterboarding, sleep deprivation, and stress positions. And it involved active collaboration with 54 other countries. But the most crucial takeaway for us today is that this program was meticulously architected and authorized by top officials. To justify it all, the Department of Justice drafted memos that used incredibly narrow legal definitions of torture. It was a highly calculated legal framework, literally built from the ground up to shield the architects. And honestly, it worked. Successive administrations effectively shielded those officials from liability by adopting one very specific mantra: look forward, as opposed to looking backwards. Investigations into senior leadership were quietly dropped. The focus was kept incredibly narrow, which meant the actual architects of these policies, the ones at the top, never faced prosecution. Of course, civil society groups like the Advocates for U.S. Torture Prosecutions, they continually pushed back against this. They argued that shielding senior officials in this way completely violates the UN Convention Against Torture, and it highlights a massive, glaring gap between our international human rights obligations and our actual domestic political realities.
Which brings us to Section 3, operating in the shadows.
So how does domestic power connect to international power? Well, a really crucial link here is 18 U.S.C. Section 951, This is the law that criminalizes acting as an agent of a foreign government inside the U.S. without notifying the Attorney General. It is the perfect bridge that connects the concept of domestic unaccountable power to the secret international webs that are woven by intelligence agencies all over the world.
Historically speaking, superpowers have always projected their influence through shadow networks and proxy conflicts. Throughout the Cold War, both the US and the Soviet Union operated deep in the shadows on a global scale. They were basically steering global politics and asserting dominance, all without ever engaging in a direct, formal military conflict with one another. It's like a giant game of chess played in the dark.
Let's dive deeper into that in Section 4, Proxy Wars and Secret Police.
To really understand this, let's trace the collapse of a specific colonial empire. Way back in 1928, Antonio de Oliveira Salazar began his dictatorial rule in Portugal. Jump forward to 1961, and you start seeing uprisings in African colonies like Angola. Fast forward again to 1974, and the Carnation Revolution overthrows the Portuguese dictatorship, which leads to the rapid, total collapse of its colonial empire by 1975. And this sudden decolonization, it created a massive power vacuum in southern Africa.
During their rule, the Portuguese regime had relied really heavily on the PID. That was their brutal state intelligence agency. This secret police force was tasked with enforcing strict socio-political control in the colonies. It's just another stark historical example of unaccountable state violence being used to maintain an empire completely from the shadows.
So when that empire fell, the superpowers rushed right into the vacuum, turning the region into a massive proxy battleground. And their strategies were fascinatingly different. The U.S. strategy, as historians document, was often clouded by this exaggerated fear of communism, which led them to back various factions somewhat reactively. The Soviet strategy, on the other hand, was heavily influenced by mid-level political elites in Moscow who favored backing very specific, ideologically aligned rebel groups. Meanwhile, the African revolutionaries themselves had to perfectly balance these two global superpowers just to secure funding and weapons.
Okay, Section 5, Flipping the Script.
Let's bring this all the way back to the modern day. In a major development just recently, in February 2025, the DOJ issued a memo titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. What this memo does is implement executive actions that specifically target private sector and university diversity, equity, and inclusion, or DEI efforts, essentially framing certain programs as illegal discrimination.
These new DOJ directives instruct the Civil Rights Division to investigate, eliminate, and penalize these DEI policies. But honestly, the biggest takeaway here, the thing that really shifts the ground, is the proposal for actual criminal investigations. The Attorney General has essentially opened the door to unprecedented criminal prosecutions over corporate DEI policies.
And the true scale of this shift becomes so clear when you compare the original legal intents. Legal analysts are suggesting the government might use 18 U.S.C. Section 241. That is a civil rights conspiracy statute. Now remember earlier? The original 1866 intent of these laws was to protect newly freed slaves from state and mob violence. Compare that to its 2025 application, where this exact same statutory framework is being mobilized to target private sector DEI programs. It is a profound, almost unimaginable shift in how historic civil rights laws are being applied today. So I want to leave you with this final, truly provocative question to think about. When laws that were specifically built to check state power are repurposed, who is really holding the shield and who wields the sword? Whether we're looking at domestic civil rights laws from the 1800s, the hidden proxy wars of the Cold War, or modern-day executive policies, the mechanisms of accountability are just constantly shifting. Thank you so much for joining me on this explainer today, and I really hope this helped you better understand the incredibly complex shadows of power.